Okay, and hopefully we are live here. Hopefully everything went right with the internet tonight. I want to welcome everybody to another episode session live stream of Firearms Nation TV. And this will also become a podcast, but I won't start recording the podcast till later. But I want to thank everybody for coming here. Hopefully we can get Andrew on the line. So let's see if Second Amendment self-defense law. So the comments are coming in. If you would mind, just for sake of production, let me know if you can hear me. If you can't hear me, if you just see me talking right now, if it's on my end, I'll try and fix it. If it's on your end, maybe something's going on with YouTube. But yeah, go ahead. Just leave some comment if you can hear me speaking. And also, while you're at it, why don't you leave a message where you're tuning in from? That's always a good thing to see. You know, we're one community here. See where everyone is hanging out and joining us. And then furthermore, if you have questions, we're going to take those questions at the end. Hey, Chris, how you doing? Chris in Self-Defense, where are you guys located? Oh, good. I'm glad the sound levels are coming in fine. That's always positive. You never can tell with technology. Okay, good. Everyone, Nolan from North Carolina, he can hear me. That is good. And Talag from Kentucky, you can hear me as well. All right, good. So things are, wow, someone already gave a thumbs down. What did we do wrong already? That's you gotta love the internet. So anyways, Lakeview, Minnesota for self-defense. Minnesota, that must be really nice right about now. It's really hot down here in Florida. And Gary from Indiana. Hopefully not from Gary, Indiana. That would be weird, wouldn't it? But let's get Andrew on the line. Let me see if I can do this correctly. Andrew, can you hear me?
I certainly can. Can you guys hear me?
Yes. So guys, if you wouldn't mind, please continue to leave these comments and let us know if you can hear Andrew's sound levels. So Andrew, how are you?
I am living the dream.
You're living the dream, and you look very nice, making me feel a little underdressed for tonight's session in my t-shirt. But thank you so much for being a part of Firearms Nation, and this will become a podcast as well. So there will be a replay of this in case you cannot stay for the whole session, and this will be also becoming a podcast, so you can listen to the content as well. Although when I do show the videos, I'll probably edit that out because on the podcast, you can't really see anything. But we're going to talk about some interesting concepts today. You know, I've had Andrew as a guest on the show several times, actually. He was on the podcast where we talked about his book, which he will have an opportunity to talk about at the end of this session. But he wrote this book, The Law of Self-Defense, and I read the book. It's a great, almost, you want to have it as your self-defense Bible. And Andrew actually has a copy that he's going to hold up. Look at that. Look at that. And he's got some props from Masad Ayub on the cover, which is always impressive. And then we're also going to, he was also on the Shooters Summit, which some of you might have found me from the Shooters Summit. There's been 2 of them. And we're actually going to have one later this year. More about that later. But Andrew is an attorney, and I'll let him introduce himself. But he's an attorney. He's written the book, The Law of Self-Defense. And frankly, if you are someone who cares about your self-defense and you are concerned about, you know, what happens if you are involved in a use of force with a firearm, what to do, you need to have this book. It's that important. He dispels a lot of the myths that you hear about on some of the lesser known shows or TV shows. And remember, guys, we don't learn anything from TV shows. There's nothing there of value other than just entertainment. So don't get any tactics or training from TV shows. But Andrew, just briefly give a quick intro on your background and why you got into writing about and talking about self-defense issues.
Sure. Well, of course, I'm an attorney, but I have a very odd legal practice, unusual legal practice. I do nothing but use of force law. So I don't have a generalized criminal defense practice. I only do self-defense, defense of others, defense of property cases. And that's been true for about 25 years. And the reason I started doing this odd practice was I'm not just an attorney, I'm also a member of the gun community. I started competitive shooting as a kid, shooting small bore rifle, and then as an adult, shooting USPSA and IDPA. And of course, as a member of the gun community, I'd go to gun matches and gun shows and gun stores, and I'd overhear other members of the gun community giving each other advice about what to do in the aftermath of a use of force event in terms of interacting with the police, explaining what happened. And the advice was often horrific. It was things like drag the body into the house before you call the police, as if the police aren't going to see that big smear of blood going up your stoop and not know exactly what you did, which, by the way, what you did was something we call consciousness of guilt evidence, tampering with the scene. It suggests that you yourself believe that your use of force was unlawful, or you would not have altered the scene to make it look better. And unfortunately, in the context of self-defense law, there aren't a lot of really good sources of information. There's a lot of bad sources, very incomplete sources of information on self-defense law, but not a lot of good sources. And, you know, with most subjects, when people learn them, if it's a new subject to them, they start with kind of 0% knowledge, and you try to get them to as close to 100% knowledge as possible, or as much as they desire. But unfortunately, in my experience with self-defense law, most people, or I should say far too many people, don't start at 0% knowledge. They start at negative 20% knowledge because of all the nonsense they've learned from other people who hold themselves out as firearms instructors or whatever the case may be, but they themselves didn't really understand self-defense law, so they don't teach it well. And then, of course, we now have the internet, including social media, and everything you see on the internet about use of force law should be considered 100% wrong until proven otherwise. So I've dedicated myself to getting the law-abiding gun community law-based education on self-defense law so they know what it actually is, as opposed to what some anonymous dude on a Facebook forum said it was.
And before we get into some of these topics, I'll ask this one question, and guys, try and keep the questions at the end because it moves up on the chat window and I miss it. But what someone wanted to know, Gary wanted to know what class shooter you are. Are you shooting USPSA or are you shooting IDPA?
So I started before IDPA existed. In fact, I played a very modest role in founding IDPA. I helped edit the first rule book. I put up their first, well, we didn't even have web pages, really. We had these email server lists. My member number in IDPA is 13. I believe they have over 25,000 members now. So I was there pretty early on. Before that, I shot USPSA, and I was a C-class shooter. I had no idea how to run a gun. Of course, I thought I did before I got into competition. And then I was in my 20s then, and a bunch of accountants and lawyers in their 50s cleaned my clock shooting USPSA. But I was really mostly defensive oriented. So when IDPA started, I was really excited. I jumped on that. And within a couple of years, I was a master class shooter in custom defensive pistol and stock service pistol, which, to be fair, would probably translate to about a high B, low A, maybe in USPSA.
And what are you currently shooting for your competition gun?
Well, now I feel bad that you asked, because I work so much these days and all the local ranges are so far away that I don't have a regular schedule anymore. But my competition gun has always been my carry gun, and that will always be the case. So my carry gun is a SIG 320 compact with a RMR on it.
Oh, very good. I am really, so you got it milled. You have a milled slide for the RMR.
I did. Yep. Sent the slide out to a gunsmith, had it milled properly, and put the RMR on. It's the RMR is it was an interesting experience, actually. It's certainly not a Band-Aid solution to anything, but my eyes were getting old, and the front sight was just a vague blur at the end of the muzzle after a while. What I found with the RMR, though, is you really need to be committed to your dry fire practice, because if your presentation is not right on track, that dots off the glass, and then you have a problem.
Yes, and for those of you who follow Firearms Nation or just are introduced to me right now, I am in that transition myself, running in competition and on duty as a law enforcement officer, carrying a red dot on my firearm, which is also a SIG 320, and I'm using the Romeo 1 for my optic, the 6 MOA, which I really like. But I have other interviews, two TV interviews, Firearms Nation TV, that is, with Young Lee and Shannon Smith, and both of those where we're talking specifically about red dots. So tune into those. You can listen to the podcast version as well at the Firearms Nation podcast. So let's get into, and guys, if you wouldn't mind, just hit that thumbs up button. The more you like this show right now, the more YouTube, against its own algorithm, is going to want to promote this to other people to see as a possible live stream to watch. So the more likes it gets, the better it is for us. We're fighting a losing battle with social media, trying to suppress. Thanks, guys. Trying to suppress our content. So whatever we can do to help, please do. But all right, let's get into one of the things that is talked about extensively on the news programs, and they are routinely getting it wrong. You know, you watch cop shows as a law enforcement officer. I watch cop shows, and I cringe every time they hold a gun wrong. Procedurally, they're violating people's rights. All these different things that they do on entertainment style cop shows. And then when you talk to the media will call things the wrong name consistently. But one of the things that they routinely screw up is the idea of self-defense, what a self-defense shooting is, and what is stand your ground. Now, let's first define what stand your ground is.
It's actually easier to go the other way, to define what self-defense is and then explain what stand your ground is from there. Self-defense, of course, is a physical act. Hopefully we all train to defend ourselves, defend our families against an attack. But it's also a legal defense that's raised in court against any criminal charge based on the intentional use of force against another person. So you use force in the physical act of self-defense, and then you find yourself charged with an assault or a battery or an aggravated assault, or if you've killed the other person, a manslaughter or a murder charge. And against that criminal charge, you raise the legal defense of self-defense. And self-defense is what we call a perfect legal defense, meaning that if you argue it successfully, it doesn't just lessen your legal liability for your use of force. It eliminates 100% of the legal liability for that use of force. So in essence, if you meet the conditions for self-defense as a legal defense, what you did was simply not a crime at all. It simply was a lawful act. And the legal defense of self-defense, just like many of your audience may know, that a crime, as defined by statute, is made up of very specific elements. And to be found guilty of a crime, the prosecution has to prove each of those elements beyond a reasonable doubt. Well, self-defense as legal defense is also made up of very specific elements. Now, in 49 states, every state except for Ohio, a prosecutor, to defeat your claim of self-defense, has to defeat any one of the elements of a self-defense claim. If you can do that, well, then what you did simply wasn't self-defense as a legal matter. Sadly, in Ohio, the defendant has to prove self-defense as opposed to the prosecution having to disprove it. But in most states, the prosecution has to disprove one of the elements of a self-defense claim. And I know the way many people are taught self-defense law, the legal aspects of self-defense seem like this very amorphous, ambiguous kind of blob of legalese. But I'm here to tell you that self-defense law is very straightforward and very simple. Just like there's only 4 rules of gun safety, there's only 5 elements to a claim of self-defense, folks. That's it, 5, only up to 5, sometimes not even that many, if one or more of the elements might be legally excused. But those elements are innocence, imminence, proportionality, avoidance, and reasonableness. That's it. It's 5 things. If those 5 things, or up to 5 things, however many are required, are present, and they are cumulative, so all the required elements have to be present. If they're all present, that was a valid use of force in self-defense. The prosecution's job is to attack any one of them and disprove it beyond a reasonable doubt. And if you can do that, your claim of self-defense collapses. So that's self-defense. 5 elements. That's it. What stand your ground does is legally waive one of those 5 elements. It legally waives the element of avoidance. In essence, what it does is redefines what qualifies as self-defense. It broadens what qualifies as self-defense, because the element of avoidance says, well, you have a legal duty to retreat before you can use force in self-defense. Stand your ground takes away that legal duty to retreat. So instead of having 5 elements, you now have 4 elements, which means there's only 4 places for the prosecutor to attack your claim of self-defense, because one of those elements obviously has been taken off the table. That's all that stand your ground does. So it's not some weird alternative way of claiming self-defense. When you're claiming self-defense in a stand your ground state, like your home state of Florida, it's exactly the same as claiming stand your ground in a state like Massachusetts, which imposes the legal duty to retreat. Except you don't have the element of avoidance. But even in Florida, you still have to be the innocent party. You still have to have been facing an imminent threat. You still have to have used proportional force, and you still have to have conducted yourself reasonably. So all the other 4 elements are still present. In essence, a stand your ground state is saying, if you were the innocent party facing an imminent attack, you used no more force than necessary, and you acted reasonably, we're not going to put you in jail for the rest of your life because we think you failed to take advantage of some safe avenue of retreat. The duty to retreat states, and there's only a minority of those, by the way, only about 14 states impose this duty to retreat, this element of avoidance. They say even if those 4 things are true, even if you were the totally innocent party and you were facing an imminent threat and you used no more force than necessary and you conducted yourself reasonably, we reserve the right to put you in jail for the rest of your life if we think you didn't take advantage of a safe avenue of retreat.
Is there in stand your ground, is there a force versus force? Like, for someone was telling me, again, this is why we're doing this, that under stand your ground, it's not just avoidance, but there's, like, if someone is coming at you, and they're punching you and you shoot them because you felt whatever, that you were in fear for your life, that escalation in force would be okay under stand your ground.
No.
Okay. So again,
so
that's why we're here.
That's just a mishmash of different concepts. It's almost difficult to unwind it. But the degree of force involved, whether it's a deadly force confrontation or a non-deadly force confrontation, that falls under the element of proportionality. So your defensive force has to be proportional to the attacking force. If you're facing only non-deadly force, you're only supposed to use non-deadly defensive force. If you're facing a deadly force attack, then you may be permitted to use deadly defensive force. But that intensity of the force question is completely independent of whether or not there's a legal duty to retreat or not. Those are 2 completely separate things.
Okay. So again, from my layman's understanding of stand your ground self-defense, why would someone go the avenue of stand your ground versus claiming self-defense? Is it simply because they want to eliminate the avoidance part of it?
Well, there is no going the avenue of stand your ground. So here's where a lot of the confusion comes up. And I blame Florida for this confusion. When Florida adopted stand your ground as properly understood, as I just explained it, taking away the legal duty to retreat, and that's all stand your ground does, they also adopted a completely different statute, a self-defense immunity statute. Now, stand your ground changes the definition of self-defense. It broadens what qualifies as self-defense because it takes away that obligation to retreat. Self-defense immunity has nothing to do with the definition of self-defense. And under Florida law, it's a completely different statute. It's not even the same statute as stand your ground. Self-defense immunity says if what you did happens to fall within the scope of lawful self-defense as it's defined elsewhere, then you may qualify for immunity from criminal prosecution and immunity from civil suit. Unfortunately, because Florida adopted both of those things at the same time, it's become common to call both of them by the same phrase, stand your ground. But they mean completely different things. So a lot of times when you see a journalist or a politician or even the sheriff in Florida, Pinellas County, who was talking about this his decision in this handicapped parking space, he's using the words stand your ground. But what he's really talking about is self-defense immunity. Now, it's understandable why people get confused because we're using the same phrase to mean 2 completely different things. Nobody claims stand your ground in any technical legal sense. Stand your ground is not something you claim. It's just a state of the law. There's no legal duty to retreat. It applies to everybody automatically. It just removes the element of avoidance from a legal defense of self-defense. You do, however, claim self-defense immunity. You have to file for a pretrial motion. You have to have a hearing before a judge. You have to argue self-defense in front of that judge at that pretrial hearing to see if you qualify for immunity. But those are two completely different things. So the proper terminology would be to reference stand your ground as being relieved of a duty to retreat, and self-defense immunity as requesting that pretrial hearing for immunity from prosecution.
Okay, and I can see a lot of people are confused here. You have people saying it wrong, but then you also have the reporters and anchors and producers of these news shows
and lawyers and judges in Florida do this too. It's for them. I mean, for the journalists, I don't think much journalists anyway. They're not very smart or very disciplined people. But you would expect lawyers and judges to value precision in language, especially legal terms of art. But they don't. So they do the same thing. They use the same phrase to refer to both completely distinct legal doctrines. So it's no surprise that people get confused.
Yeah, and it's you have the victim's family, everyone's saying stand your ground, and you have, if you do a search, and I just noticed this today, and I'm probably behind the times. If you guys go on Google and search for anything, the only thing that are popping up are very left-leaning media sources. You don't get any conservative or right-leaning like Fox News. You don't get anything in your search results. Everything is all these left-leaning media. So you're getting that perspective, and everything was about the case we're going to get into. Everything was just very anti-stand your ground, and how it is hurting people by having this kind of defense to say stand your ground. It's just the worst thing ever.
So what I just described was the proper legal meaning of stand your ground, the misuse in a legal context of stand your ground. But there's also a third problem, and that is the phrase stand your ground has simply become a political hot button phrase. So people throw out the phrase stand your ground having absolutely no understanding of it at all. To them, it just means evil. They use it in the place of the word evil. So when they want to make something sound bad, they throw in the phrase stand your ground.
So what I want to do now for the people who are tuning into this, and first of all, welcome back anybody who's been to the channel before. Welcome to the new people who have tuned in. I see we have a lot of people already coming into here. Just please leave a quick message where you're from so we know how far this YouTube live stream is going. And we're going to show a clip from, this is just the raw surveillance video from the parking lot shooting here in Florida in Pinellas County, it was in unincorporated Clearwater, which is near Tampa. And I'm going to see if I can do this with the magic of technology. All right, so you should be seeing there we go. All right, so those of you that don't know this, the setup here is a older gentleman who happens to be white, wanted to use a handicap spot, and when he gets there, there's someone parked in the handicap spot without a placard. And what he does is he goes and looks at the back of the car to see if they have the tag that has the placard, and then he looks to see if they have one hanging. Then he looks in the front. Then he starts getting into an argument with the driver. Now, meanwhile, on the inside is the ladies. I think it was her husband was inside, and when he starts getting a little upset, now it's playing, the guy comes out, and you're going to see that. Let me just fast forward a little bit. He's just arguing back and forth, lots of arguing going on, and it's causing quite a little scene. You see this guy here is, watching what's going on. And then finally here he is, the husband coming out, and he's going to right there push this guy who is an older gentleman down, but he responds by taking out his gun and shooting him. The guy retreats into the store, and then eventually later on, he succumbs to his wounds. So what the video cuts off right after this guy gets up and gets I guess he gets on the phone. So let me go back to Andrew. So Andrew, you were able to watch that as well. It's always hard when we watch videos of shootings because you know someone possibly just lost their life, and in this case, they did lost their life. So we have a lot of things going on here, a lot of actions that caused certain things to keep steamrolling into effect. So you have the person parking in the handicap spot, and if you just say if they just didn't park in the handicap spot, none of this would have happened. But so they did park in the handicap spot. The guy comes up and essentially, he's not the police, but he's obviously upset because he needed the spot, and he starts interacting with them. Probably not the best thing to do.
Sure. Well, as I mentioned a few moments ago, a legal defense of self-defense is very straightforward. There's 5 elements. What gets complicated is not the legal framework. What gets complicated is reality. Reality is complicated. And unfortunately, there's a tendency for normal people who are not trained in the law, to take into consideration an enormous body of facts and evidence that aren't actually relevant to the legal analysis. So when if I were doing a legal consult on this case, as I do on a great many cases every year, I apply those 5 elements of self-defense I already described. So the first element is innocence. Innocence says, well, who is the initial physical aggressor? That's the only question for innocence. Now, the parking in the handicap spot's not an act of physical aggression. The man walking up and chastising the woman for parking in the handicapped parking spot, that's not an act of physical aggression. Words alone cannot be an act of physical aggression. It's uncontested that in this event, the initial physical aggressor was the boyfriend, not the old man chastising the girlfriend for legal purposes. Now, I know it's common for us to use phrases, words like provoked, or, the older guy provoked the confrontation by chastising the girlfriend. And that may be true in terms of common parlance, but it's not true for use of force analysis. The old man was not the physical aggressor in that confrontation. The boyfriend was. So that's the element of innocence. It's on the shooter's side, because the boyfriend was the initial aggressor. The next element is imminence. Was the shooter facing a threat of some harm about to happen right now? Well, this is not a crystal clear case of self-defense. This is a marginal case of self-defense by any measure. But I would suggest that if a 50-year-old something has just been hurled to the street, this was not a gentle shove by someone half his age, who's now standing, didn't run away at the side of the gun, but it's now standing a step and a half away from kicking him in the head or stomping him on the sidewalk. I think a reasonable person could perceive an imminent threat. The third element is proportionality. I'm going to skip that for the moment and come back to it, because that's actually the key element in this analysis. The fourth element is avoidance. Well, we're in Florida, so it's a stand your ground state. Avoidance doesn't apply. But even if this were in a duty to retreat state, you're only ever required to try to retreat if you have a completely safe avenue of retreat. I would suggest that if you've just been smashed to the ground and your attacker is only a couple steps away, it's probably not. I don't know if you saw the end of the video, but it takes this guy about 30 seconds to get up off the ground. So I don't think retreat was a viable option, even if it had been required, which it wasn't in Florida. The fifth element is reasonableness, and that ties in with proportionality. So I'll come back to this. The real issue in this incident is, do you believe that the combination of the boyfriend throwing the shooter to the ground and then staying within a couple of feet of him? We saw other witnesses flee the moment they saw the gun come out, right? The boyfriend stayed within a couple of feet. Would that strike in a reasonable person's mind, a reasonable person being the shooter, a fear of a deadly force attack, an imminent deadly force attack? Well, deadly force includes not just force capable of causing death, but force capable of causing grave bodily harm. And a large person, larger than you, half your age, who just threw you to the ground, who's staying close enough to stomp on you, I could make that argument that that represents an imminent threat of serious bodily injury, which would be a deadly force threat, which would justify the use of deadly defensive force. The boyfriend didn't put his hands up. He didn't back further away. Of course, the argument could also be made that if you don't believe that conduct by the boyfriend represented a deadly force threat, well, that changes the analysis then, because if it was only non-deadly force, then there was no justification even to draw the gun. And if there was no justification to draw the gun, then what the shooter actually did was he may have been the victim of a non-deadly force attack, but he unlawfully escalated that to a deadly force fight by drawing his gun, in which case he's actually become the initial deadly force aggressor in a second fight. So that's really the crux of this analysis. What do you believe? Do you believe that the boyfriend's conduct, throwing him down, standing over him within a couple of feet, constitutes a reasonably perceived threat of serious bodily injury, or don't you? If you do, then it was likely a lawful use of force. If you don't, then it likely wasn't.
So if you look at the actions of the boyfriend, or I can't remember if it's boyfriend or husband. I can look that up.
Boyfriend.
Boyfriend. Okay. I was saying husband earlier.
But I mean, it doesn't matter for use of force purposes, of course. But
right. Him coming out and being the aggressor right there and committing a battery. And in Florida, we have, and I'm sure in some other states too, they have, if you do it against somebody older than a certain age, like 65, then it ups it. Possibly this type of thing could have been up to a felony right now. And, he's worried about, he could have broken his hip. He could have, broken other bones. Now we got great bodily harm. He is defending himself from that action, from continued assault or continued battery.
Right, and that's the key, right? He's not defending himself from the shove. The shove already happened, so it's over. He's defending himself against the next act of force by this boyfriend. So
when he comes out, or his attorney comes out in the media and says he's claiming stand your ground, is that just a misinformed way of saying that he is claiming self-defense, but he is utilizing the stand your ground part of that, which is he didn't need to get up and run away from this?
Right. So you don't claim no duty to retreat. That's just what the law is. It just exists for everybody. So you don't claim that. The lawyer may have meant he's going to claim self-defense immunity. He's going to request that pretrial hearing. He's going to make his argument of self-defense in front of the judge pretrial and try to get a grant of immunity from criminal prosecution. That would be a legally logical thing to do. But using the phrase stand your ground to describe that would be an incorrect use of the phrase. What he would say is my client's going to seek self-defense immunity. When he throws out the phrase stand your ground, in this context, I don't believe it has any application because it would only be relevant if safe retreat would have been possible. And I don't believe safe retreat was possible here because the duty to retreat is only ever imposed if you can do it with complete safety. You're not required to increase your jeopardy to try to escape. And if you're on the ground and your attacker is hovering above you, struggling to get up, and then that's not a safe avenue of retreat.
And I think we discussed this before, but going back to George Zimmerman and Trayvon Martin, that's when I guess Stand Your Ground was passing in Florida, and it got intertwined with that case. But that case also wasn't a traditional Stand Your Ground because he had no way to retreat. The guy was on top of him.
Well, I believe Stand Your Ground passed in 2005, and the Trayvon Martin shooting, I think, was 2012, if I recall correctly. So it was quite some time later. But yeah, you're quite right. The Zimmerman case had absolutely nothing to do with Stand Your Ground because Zimmerman was literally pinned on the ground by Trayvon Martin. Escape was impossible. Now, some people misunderstand what this duty to retreat and being relieved of it means to suggest that, well, at one point, for example, Zimmerman got out of his car. Is that a violation of his duty to retreat? But the duty to retreat's not triggered until the time you're making the decision about whether to use defensive force. So it's not triggered until you're facing an attack. You're not required to retreat from everything all the time, every day. When there is a legal duty to retreat, you're required to retreat when you're facing a threat, you're considering using force, but you have a safe avenue of retreat you could take instead. In the Zimmerman case, he didn't know he was under attack until he was punched. When he was punched, he was on his back. When he was on his back, he was mounted. And he tried desperately to escape from under Trayvon Martin. That's, in fact, squirming on the ground is how his gun got exposed, and it became necessary to use deadly defensive force. But Zimmerman never had a completely safe avenue of escape from the moment that Trayvon punched him. It just didn't exist. And if it didn't exist, even if Florida didn't have stand your ground, Zimmerman would still have had no duty to retreat, because you can't have a legal duty to do something that's not possible. So stand your ground was completely irrelevant. By the way, stand your ground is irrelevant in almost every one of these high-profile self-defense cases you see. Stand your ground or a legal duty to retreat is often relevant in bad guy cases of self-defense. People who are falsely claiming self-defense to justify some criminal use of force. Everyone who's charged with aggravated assault eventually tries to say it was self-defense. But in good guy cases of self-defense, the kind of cases people like you and I might find ourselves involved in, stand your ground is almost never relevant, because when good guys have a safe avenue of retreat, we almost invariably take it. So I'm a big fan of stand your ground. Don't get me wrong. I think it's good public policy. It's law in about 36 states. I think it should be law in 50 states, including states you might not expect, like California is a very vigorous stand your ground state. But it rarely actually comes up as a legal issue in good guy cases of self-defense. We hear about it a lot because the media doesn't understand what it is, but they know it's a hot button phrase, so they like to throw it into every use of force news story that they write about.
Well, I guess my confusion came from that case, because previously never really heard it. And then here in Florida, that's all we heard about, and we continue to hear about. Why is there an assault on stand your ground? What is it? So, especially on the other side of the aisle here, why is it such a bad thing that they have to keep attacking it, even when it's not relevant to what the case that they're seeing?
Well, keep in mind that the people attacking it don't know what it is either. They don't actually know what stand your ground is. As I mentioned earlier, stand your ground has become a political hot button phrase for bad. It's just a bad thing. It's an evil thing. And we need to understand that. And frankly, it took me much of my adult life to come to this realization, because being a lawyer, I'm a very kind of structured, disciplined, logical thinker. It's required part of the trade. But a lot of people aren't. And we need to distinguish between reality and being technically correct on the one hand, and perception on the other, because decision-making for most people is not driven by logic and technical precision. It's driven by perception. And if people can be convinced that stand your ground, if they can be convinced to perceive stand your ground as meaning quote unquote evil, well, then if you're a politician, you want to run against evil, right? You want to tell your constituents, I will protect you from evil. But they don't say evil, because now they have a phrase they can stick in place of evil, and that phrase is stand your ground. So whenever you hear any of these politicians ranting and raving in front of some kind of protest about stand your ground law, they have no idea what stand your ground is from a legal perspective. But they know it's something that scares their constituents, so they'll promise their constituents to protect them from this boogeyman, stand your ground.
I don't know if you know the answer to this, but I'm going to ask you anyways. Do you know how stand your ground came about in the first place? What was the need to have stand your ground put into the system?
So stand your ground is a very old phrase, but to look back in history. So most of our self-defense law, I mean, it goes back thousands of years to the ancient Greeks and Romans, but I'm going to say more contemporaneously. I'm still looking back hundreds of years. Our law came from Old English common law. And under English law, there was a legal duty to retreat before you could use deadly force against another person in self-defense. And part of that reflected their understanding of government and the role of the individual in society compared to government. And part of it was a reflection of the typical weapons available to people at that time to defend themselves. So in terms of the perception of the individual with respect to government, people were servants to the crown. They weren't, as we think of individuals today, free individuals with liberty. They were, in a sense, the property of the crown. And the crown didn't want its property killing each other if they could just walk away. Second of all, most of the common weapons at the time were not handguns. They were impact weapons. And so if you could create a distance between you and the other fellow of 30 or 40 feet, you were pretty immune from harm from his impact weapon. So the court said, hey, listen, just get 30 or 40 feet away before you have to make the decision to use deadly force against that guy. Of course, by the time America was born, firearms were commonplace, and no one's outrunning a 1,000 foot per second lead projectile. Also, we had a different conception of the individual. An individual had inherent human natural rights independent of the government. He was not a piece of property of the government in any sense of the word. So America has always had as a default position stand your ground, that there was no legal duty to retreat. First of all, you can't retreat from a gun, and everybody has guns. And second of all, you have a fundamental natural right to your own life and to defend your own life. And in fact, if you look at many states that are stand your ground, so I said about 36 states are stand your ground states. Only about half of those have stand your ground statutes that they've passed in the last 10 or 15 or 20 years. The other half of those states have simply always been stand your ground states. You find it in their court decisions. In California, it's in court decisions going back to the 1800s. If you look at California statutes, you won't find a stand your ground statute. They don't have one. They've never had to pass one because it's always been the law in the state as reflected in court decisions. In the mid 1900s, there was kind of a progressive aura. I don't mean progressive in the way we use the word progressive politically today. I mean a Theodore Roosevelt kind of progressive. And people tried to make a lot of the criminal law more lenient than it had been. And they took the position that, human life, even the human life of a criminal, deserves to be saved if that can be done at all safely. And therefore, we're going to start imposing a legal duty to retreat. So they added that duty to self-defense law of the time. Then 30 or 40 years later, states like Florida and a lot of the other states that have since adopted stand your ground statutes have decided, you know what, that was a bad call. We think that people who are innocently attacked should have a right to defend themselves without having to first retreat. So we're going to reverse that and adopt a stand your ground statute. But the default norm in America law has always been stand your ground.
Well, thank you, first of all, for defining that so eloquently. That answers a lot of questions, and hopefully more people will take the time to either listen to this or to listen to you on your show to get a better grasp of what stand your ground really means.
By the way, I just want to interject for a moment because I see someone in the comments here has posted up a U.S. Supreme Court case, Beard v. United States, and they're doing that because it talks about stand your ground. But here's something people need to be very careful about. 99.99% of self-defense cases take place at the state level to which U.S. Supreme Court decisions are not applicable. I read thousands of state appellate court self-defense decisions every year. They never talk about U.S. Supreme Court decisions in the context of use of force law. They talk about it a lot in terms of our fundamental constitutional rights, like a right to effective assistance counsel and all those other fundamental rights. But use of force law, if you're involved in a use of force event and you're being tried in state court, those U.S. Supreme Court decisions are going to do nothing for you. So don't overread them. Now, if you're somehow in an extremely odd situation where you end up in a self-defense court case at the federal level, I'm not even sure how that would happen. You might have to be on federal land or some obscure thing would have to happen. Then those decisions would be relevant, but not at the state level.
And again, I want to stress, knowing this ahead of time, knowing this information is really important. And that's why his book is, The Law of Self-Defense is one of the best things that if you're going to carry a gun for self-defense, you need to know this stuff. Besides getting that book, you also need to be getting training. You need to have an understanding of your concealed carry laws in your state, because every state is different. And you need to know how to interact with the police. And before we get into that aspect of the show, I just want to, again, welcome anybody who's come in to join us for this live stream with Andrew Branca, Esquire. And if you can leave a comment where you're from, going back on the comments here, we have people from Georgia, We got some from Virginia, North Carolina, Homestead, Florida. Hey, Terry, my neck of the woods. We have somebody all the way from Winchester, California. Winchester. I lived in California for 10 years. I'm trying to remember where Winchester is. I think it's like south of LA, if I'm not mistaken. San Diego. Great. So we have people all over this country. So, stuff like this, it's important to know, knowing your laws. And again, carrying a gun for self-defense is very important. You need to be trained on how to use it. And you also need to know the CCW laws. Now, in Chicago recently, they had a police-involved shooting with someone who was carrying concealed. And again, it was racially charged. A lot of these cases somehow end up being racially charged, and the media loves that. They love to stir the pot and create things. So the Chicago Police Department released footage right away, which is out of the norm. Usually like to have all the pieces and all the evidence collected before they start even talking about it. But here they released it and trying to keep the fires from burning. It wasn't that successful. But so I'm going to show this clip of this person was somewhat seen. They weren't concealing the gun that well. They had reason to believe that he had a gun, so they went up to question him, and things went south from there. So let's see, with the magic of technology, I can get this video playing. All right, let me see if I can make it bigger for you people. There we go. All right, so this was released. This is the body cam footage from one of the officers. There's a gentleman there. You see he's got something definitely under his shirt. And now they're trying to detain him. He's getting froggy, and there they stop it. And you can see clearly it's a very full-size gun and a magazine. He goes for the gun and is shot. Very graphic video. And we'll have some talking points about that. Let me get Andrew back on the screen. There you go, Andrew. So you just watched this video. I think we were discussing in the pre-show that you did see it previously. Some bad tactics there for somebody who's carrying a firearm. First of all, I got to say, carrying a full-size gun is going to be very hard to conceal. And if you're out and about in public, you don't want to be printing, right? So printing is when someone can see through your clothing that you have what looks like a firearm. Brandishing is when that firearm is visible. So he was printing. He wasn't showing the gun, but it was enough that the police came up to question him. Your thoughts on this, Andrew?
Well, I mean, from a use of force perspective, there's no logical decision-making here. The threat was completely evident. We could step through the 5 elements of a self-defense claim if you like, but it hardly seems worth the effort. I would note in passing, I've carried a gun pretty much every day of my adult life. 25 of those years were in Massachusetts, where if someone had thought I was carrying a gun, and it would have been lawful, but in Massachusetts, guns are perceived by much of the population like rattlesnakes carried around your neck. If I'd been in the grocery store and someone had believed I was carrying a gun, they would have called the police, and I would have had that interaction. That never happened. I carried for 25 years, most of those years a full-size 5-inch 1911, and I never got made. So there's no reason for this to happen, folks. Just have a good belt. This guy does not appear to have had a good belt. Have a good belt, good holster, good gear. For Pete's sake, if you're going to CCW like a professional. It's really, you owe it to yourself and your community. But in the event that sadly you were somehow made and someone called the police and you had a police interaction, I urge you to be utterly compliant with that officer's instructions. He's responding to a man with a gun call. He doesn't know you. He doesn't know what you might be prepared to do with that gun. By the way, you might be prepared to do what this guy did, which was resist them and then draw his gun. And frankly, this bad guy was pretty proficient in getting that gun into play. Those cops were darn lucky he didn't shoot a bunch of them. Somebody, perhaps out of frame, was really on the ball in that Chicago Police Department and managed to take that guy down. I presume he didn't shoot any of the officers. I don't know for a fact, but they got him down pretty quick once he got the gun into play. I would also note that this guy had a gun and a spare mag on his belt, so he was about as prepared as most people who CCW lawfully. That's what I carry: gun with a spare mag and a flashlight and all the other nonsense. From a use of force perspective, clearly this guy was the physical aggressor in going for his gun. Now, you might say the cops were the initial physical aggressors, but that's not the same thing. What we mean by the physical aggressor is who was the unlawful physical aggressor. The police using force in this scenario would be a lawful use of force, so it wouldn't apply. If someone's drawing a gun, it's an imminent threat, right? It's a threat about to happen right now. If in terms of the element of proportionality, it's clearly a deadly force threat, not a non-deadly force threat. In terms of avoidance, you can't outrun a bullet. So even if a duty to retreat existed, it wouldn't apply. And everything these cops did, in my perspective, was reasonable. So I'm sure it'll be ginned up as another, cops shoot black guy stories. But legally speaking, I simply don't see anything wrong here in the cops' conduct at all.
Now, it's interesting that this took place in Chicago, where it's not that commonplace that people get CCWs, and for someone to be carrying concealed, you run the risk if you do not have permission to carry a gun. If you go to a state that doesn't allow your state's reciprocity to carry a gun, don't be doing that. You are running the risk of serious things, and it escalates too, because you're involved in something and then they find out you have a gun. That's just going to steamroll into a whole other can of worms for you. With attorney, they always say this too. Like in New York, the DA can indict a ham sandwich. I mean, you're running the risk if you carry where you're not supposed to be carrying.
Well, you don't even have to worry about you're right. A DA anywhere can indict a ham sandwich, but it would be a possession charge, and there's no trouble indicting in a possession charge. Clearly, you were in possession. That's all that's required. That's undisputed. So it's an easy conviction for a prosecutor. And by the way, people should keep in mind that the more law-abiding you are, the cleaner your record is, the more likely they are to stick you with the weapons charge. And that's because, believe it or not, weapons charges are dismissed in the context of bad guys all the time as part of a plea deal. They get them to plead to one lesser degree crime so they don't have to expend the resources to take them to trial. And among the most commonly of the dismissed charges are the weapons charges. They plea them down to something else. But if you're a law-abiding citizen and then you're one of those half a dozen states that just has a phobia about firearms, like New York, Massachusetts, New Jersey, Maryland, California, if they catch a nominally good guy with a gun, someone with no criminal record, never done anything before, but he thought, I'm not supposed to carry here, but I'm going to do it anyway, they will prosecute that person because they're trying to send a message to all the other good guys. No sense prosecuting a bad guy in a weapons charge because the other bad guys are not going to learn a lesson from that. But if you prosecute the good guy, the guy who's always been an upstanding citizen, is employed, supports his family, and you can put him in jail for a mandatory minimum year like they would in Massachusetts, well, guess what? All the other good guys are going to learn a lesson from that, right? And they're not going to take the risk of carrying unlawfully while they visit Massachusetts.
All right, so we're almost at the hour mark, and I want to get to people's questions. Real quick on this one, and people who are watching, first of all, thank you. And if you have questions for Andrew or if you have questions for me, start putting them in the comments, and we will get to them as much as possible. But someone did ask if you applied what we saw in that video, if that was done by a civilian. So it wasn't a law enforcement officer that interacted with this person. It was a civilian, and he ended up shooting the person in the same manner. Would it be under the same thing, or because law enforcement doesn't have a duty to retreat and all this other stuff, would have gone a different way?
Yeah, it's completely different situations. And by the way, this is one of the reasons, no offense to law enforcement, but why it's often hazardous for civilians to take use of force advice from law enforcement officers, because they swim in different waters. They have fundamentally different responsibilities. So, for example, they're responding here presumably to a call of somebody suspects this guy has a gun, so they go to investigate. I'm sure they started with questions. Sir, do you have a permit? Are you carrying a gun? That kind of stuff. The guy became non-compliant, and that's how things escalated. Well, a non-law enforcement officer has no no reason to get into that interaction in the first place. And if a civilian had done that, then the question would be, well, would it be reasonably foreseeable that he's approaching a guy with a gun he suspects has it unlawfully and he's engaging in a confrontation? Is it reasonably foreseeable it would go violent? Well, I think it is reasonably foreseeable. So no, a civilian would simply never find themselves in this situation. Or if they did, they would find themselves in it because they acted like a cop. And I tell people all the time, unfortunately, there's quite a few people in the self-defense community who are non-cops who would like to be able to act like cops, hold people at gunpoint, make citizens arrest. Folks, if you want to do that, here's how you do it. You go to the police academy, you graduate, you get sworn, you get a badge and a gun, you work for a department, and then you go arrest bad guys. That's what you do. But if you're not a cop, don't play the role of cop.
You bring up a great point. And before I get to some of the questions that came in, I just want to ask your opinion on this from a civilian perspective. All right. So in law enforcement, we draw our guns to hold people, right? As someone's doing something bad, we'll pull out our weapon and say, don't move, get on the ground, order commands, and then have someone put handcuffs on them. In the civilian world, are you allowed to pull your gun to hold somebody, or is that considered assault?
Well, it would depend on why you pulled your gun. I mean, I wouldn't recommend pulling a gun unless you were pulling it to attempt to neutralize an apparent deadly force threat.
I'll give you the example.
But a lot of times, of course, most civilian uses of guns for self-defense don't involve shots fired. The civilian pulls the gun. The bad guy decides he doesn't want to get shot that day. And so the civilian never has to shoot. Well, now you can find yourself in an awkward position of, well, what do I do now? The bad guy's dropped his knife. He's just standing there. I've got my gun out. Is that holding him at gunpoint? I mean, I would certainly not explicitly hold him at gunpoint. If it were me, I'd want to do everything in my power to separate myself from that person. So if he's not going to back away, I'm going to start backing away. My job is to save my life. It's not to make some kind of citizen's arrest. And by the way, for people who imagine in their heads they're going to hold someone at gunpoint, I would recommend the next time you're dry firing, when you've emptied the gun, double-checked it, all that jazz that you need to do for safe dry fire, just go ahead and hold your gun out for a while and see how heavy it gets. It doesn't take very many minutes before it gets really, really, really heavy held out in front of you. Plus, presumably you pointed that gun at that person because you reasonably perceived he was attempting to kill you or cause you serious bodily injury. Why would you stay proximate to a person like that? Why would you not create distance from a person like that? So no, I would never recommend that anybody hold anybody at gunpoint if they had any other option.
All right. So the example I was going to give you, because you can go, all right, so someone's in your house, different story. But you're out and about, you see someone breaking into a car, you want to stop it, and you draw your gun and say,
Why?
Well, okay, well that's going to be the question that the attorney and the judges and the prosecutor is going to ask. But it's been done where people see a crime being committed and want to do something other than being a witness. So they put themselves in a situation. You say, don't move. I've got a gun. Whatever. You're breaking into my car.
Right.
Bad
So
idea.
There's a whole bunch of problems here. One is breaking into a car is a property offense. It's not a threat to human life. And you're not allowed to use deadly force in defense of mere personal property, like an unoccupied car. So by going to the gun, you've already broken the law because you've gone disproportional. You've violated the element of proportionality. You're using deadly force in a situation that only allows at the most for non-deadly force. So yeah, you're looking potentially at an aggravated assault charge, which by the way, is good for, depending on the state, anywhere from 10 to 40 years in prison once you add the firearms enhancement, sentencing enhancements on top. So just by going to the gun in terms of a sheer property crime, you've already violated the law. Unfortunately, the reason this happens is because too many people learn their use of force law from anecdotes, right? If you're an NRA member, for example, you get one of the magazines, right? American Hunter, American Rifleman, First Freedom, and they all have that armed citizen page in it with these little paragraphs about people who use guns to defend themselves and their family and their property. And it always works out great for the gun owner. The cops show up, pat him on the back, good job, citizen. The bad guy gets arrested or he bleeds out down the street. But the truth is, a lot of those anecdotes, when I read them from my perspective as an expert on use of force law, a lot of those uses of guns were not lawful. They were unlawful. But the person got a lucky break. The authorities chose to use their discretion not to arrest, not to indict, not to prosecute, not to convict. Now, unfortunately, if you don't understand use of force law, when you read that, you go, well, what that person did must have been lawful. They held the gun at someone breaking into their car, their unoccupied vehicle. That must be lawful. They weren't even arrested. No, it doesn't necessarily mean that. It may mean they just got a lucky break of the authority's discretion. But if you don't understand the fundamentals of use of force law, you're unable to distinguish those two scenarios. And a lot of people learn their use of force law from these kinds of articles, from these kinds of reports. That's why I say so many people are walking around not with 0% use of force law knowledge, but negative 20%, because they've learned a bunch of stuff, but it's all wrong.
Mm-hmm. Absolutely. So I keep going back to this. Know the law. Get his book. Read your statutes. Anywhere you go, there's going to be a website. Make sure it's a credible website. And I'm sure one of the good places is, I'll look it up. I don't want to give out the wrong name, but it's my buddy Riley Bowman and his stuff. They have a really good website. I just want to make sure I get the right website. But let's take some of the questions, shall we, Andrew?
Sure.
So let's see. I saw one that was fairly interesting about, okay, so Agile Canine Top Dog. Could you comment on the recent Ninth Circuit ruling on open carry?
So I should distinguish between what my area of expertise is and what the Ninth Circuit covered. Now, I did write extensively about the Ninth Circuit decision. I did it over at a website called Legal Insurrection. So if you want to go over to legalinsurrection.com after the show, you can look up what I wrote. But my expertise is really use of force law, not gun law. So I know about as much about gun law as any well-informed gun owner would know, maybe a little bit more. I know a lot about use of force law, but gun law is not really my thing, partly because it varies so much from state to state, even within states, from county to county and city to city sometimes, that I think it's impossible for any one attorney to have 50 states worth of gun law knowledge and be competent at it. So use of force law, my thing, gun law, not so much.
Okay, just your opinion. What's your take on open carry?
Well, I'm a what do they call it? Gunamentalist. I am a Second Amendment hardcore believer. My position is that all preemptive gun laws applied to law-abiding, mentally sound American citizens are facially unconstitutional. I don't think there should be any permits for anything, including NFA weapons, if you're a law-abiding, mentally sound American citizen. Now, if you violate one of those things, if you're a lawbreaker or you're not mentally sound or you're not an American citizen, then I give the government the right to impose constraints. But the language of the Second Amendment is not confusing. The right to keep and bear arms shall not be infringed. And the Supreme Court has said that applies to the states too. The problem we have right now is that the federal appellate courts are in open rebellion against the Heller and McDonald decisions. And something needs to be done about that. And fundamentally, that's going to be a political solution. So, elect the right people, folks. Get out there, work for your candidates, because listen, just look at how the left talks about us now. We're all Hitler. We're all monsters. You think they're going to think any better of us if they get back in control? Or you think they're going to treat us like Hitlers and monsters?
Can you comment, this is from Billy Miller, can you comment on carry insurance programs such as U.S. Law Shield?
Yeah, so there's a lot going on with these insurance programs right now, partly because of a lot of the political dynamics. So in general, my general position has always been to, and by the way, in full disclosure, I've worked with many of these companies. I'm currently partnered with CCW Safe, so you should all take that into consideration. I like to think I'm giving an unbiased position, but you're entitled to know that. In general, my position has been not so much to recommend any one program, because they're all sufficiently different that there'd be no way for me to know which particular one would best suit any individual's needs. But I can definitely recommend against certain types of plans. The ones I recommend against are the ones that are either entirely or largely a reimbursement type program, where they reimburse your legal expenses if you're acquitted. Folks, you don't need that. That's a crock. You need that money to get acquitted. It's like someone saying, we'll give you an army if you win the war. You need the army to win the war. So you want a plan that's going to compensate you for your legal expenses as they're incurred, not after you've already won. And by the way, for the companies that are reimbursement plans, what's their incentive? It's actually for you to get convicted, because if you get convicted, they don't have to pay you anything. That's not the kind of partner I would want. The other kind of plan I don't like is the plan that assigns you an attorney rather than compensating the attorney of your choice. Listen, folks, if you're being charged with a serious felony, your life as you know it is in that attorney's hands. You need to have 100% confidence that he's fighting hard for you. And I hate to say it, but not all criminal defense attorneys fight hard. A lot of them, they do what they're obligated to do. They crank the handle on the machine, but they don't do more than that. And you want the attorney who's going to do more than that. So you want the right to be able to choose your own attorney and then have the policy reimburse that attorney. Don't be stuck with who they pick. And by the way, what's their incentive for those plans? To choose you a $500 an hour attorney or a $100 an hour attorney? Think about it. You want to be able to choose your own attorney. More recently, because of the politics following some of these school shootings, a number of these self-defense insurance plans, the way they work is they're not actually, we all use the phrase self-defense insurance, but they don't actually provide their members with insurance. They provide their members with a commitment to reimburse the members' legal expenses or to pay the legal expenses as they're incurred. And the company itself is insured by a third party to insure them for those expenses that they pay out to the members. The trouble is that if they're the companies that have been themselves insured by a third-party company, those third-party insurance companies are coming under a lot of political pressure, especially in New York with Governor Cuomo. So, for example, my understanding is the NRA Carry Guard program, its insurance backer has completely dumped it. So it can't offer this quote-unquote self-defense insurance product anymore anywhere in the country because Lockton, their insurance backer, has dropped them under political pressure. Now, you'll want to fact check that. I'm not an expert I don't follow this stuff in the news, but that's my current understanding. And I think another company is USCCA, who I've done work for. USCCA within New York State, I'm told they're not writing any more policies within New York State because they don't want to have to deal with the governor applying pressure to their insurance company. There are some of these companies that don't have third-party insurance, and in that case, they're not susceptible to this kind of political pressure. One of those is CCW Safe. It's one of the things I like about CCW Safe. They use an insurance company, but it's an insurance company that they created. It's what's called a captive insurance company, and it's located offshore. So it's not susceptible to this kind of Governor Cuomo political pressure. So they don't have to worry about that. Another example would be the Armed Citizen Legal Defense Network. I've been friends with those guys for decades. Masa Youb's on their board. Tom Gibbons is on their board. Dennis Tuller is on their board. It's a great organization. They don't use an insurance company at all. They take a certain percentage of member fees and set it aside in a legal defense fund. So they're also not subject to this kind of political pressure that's currently being brought against these third-party insurance companies. But it's something to think about. As far as CCW Safe, if folks are interested in learning more about them, you can point your browser to lawselfdefense.com/CCW Safe. But I am partnered with them, so caveat emptor, make your best judgment.
Awesome. Thank you. Some questions that I don't really understand the context, but I'm going to ask anyways. Where was it? Something about Marietta, Georgia. Can you discuss? Well, first of all, do you have a web class this Saturday?
I'll have to come back to that. I have to check my schedule.
Okay. Nolan Jarvis was asking if you have a web class. And then Troy is asking, what happened with the company in Marietta? I don't know if that's some sort of inside question that you know the answer to. I don't know what that is.
I'm not sure exactly what I'd have to guess at what he's talking about, and then I might be answering the wrong question.
Okay, so Troy, if you want to get an answer to that question, if you're still on, just give us what that means. All right, so just a couple more here. I think it's Leprechaun Tar is asking, if one is in a state that has a castle doctrine, can one hold a forceful intruder till the police arrive?
Okay, so like stand your ground, castle doctrine is a phrase that's frequently badly misused. First of all, every state has a castle doctrine. The castle doctrine is it's kind of a variant of stand your ground in that it relieves you of an otherwise existing duty to retreat. So if your state would normally have imposed a legal duty to retreat, it relieves you of that duty if you're in your castle. So if you're in your home, you no longer have a legal duty to retreat. Now, that's a general statement. There's several different flavors of castle doctrine. But properly used, the phrase castle doctrine does not mean exceptional permission to use different kinds of force against another person. That's an improper use of the phrase castle doctrine. Properly used castle doctrine simply means if you would have had a legal duty to retreat outside your home, you don't have it inside your home. Period. That's all it means. Now, there are laws that create special provisions for the use of force in the context of your home, but those are defense of highly defensible property laws. They're not quote unquote castle doctrine laws. And again, I don't mean to criticize people who are using castle doctrine in the improper, broader sense. I know why they're doing it. It's because they were given misinformation. That's not the proper way. But if he's asking if an intruder is in your home, can you hold them at gunpoint? Well, if you would have had the privilege to use deadly force against them, if you would have had the privilege to shoot them, you can certainly not shoot them and just hold them at gunpoint. That would not be the ideal situation, but unfortunately, sometimes bad guys don't do what we would prefer, which is run out of the house. A genuine intruder in your home is one of the few situations in which I would say, yeah, maybe holding him at gunpoint is what you need to do because you're not leaving your home and leaving him behind. You're staying, and if he refuses to leave, I'd rather hold him at gunpoint, wait for the cops to show up than actually shoot him and then have to face that criminal liability. But the real question is whether or not you would have been entitled to use deadly force at all. If the answer is yes, well, then you would be entitled to hold him at gunpoint if it became necessary to do that. Personally, I'd like to shout at him to get out of the house.
Right. And go back to understanding the law. Like Andrew said earlier, if the guy sees you and runs out the door and you shoot him, don't drag him back into your house claiming that he was a threat to you. But yeah, when it comes to these things, know what your state is, what they follow, because if it is, I might be wrong, but I've heard that in some of those states where you do have a duty to retreat, that even applies to your house. Like if that guy's in the house, you can run out the back door. You should have run out the back door. Is that correct, Andrew?
No.
Okay, good. See, we're here to dispel these myths.
But there are some different flavors of castle doctrine. So one variation of castle doctrine is who can claim the privilege of not having to retreat. Now, if you're in your own castle, you have castle doctrine privileges, clearly. But what about if you're in someone else's castle? What if you're visiting a family member? You're in their house. Well, clearly in their house, they have castle doctrine privileges. They don't have to retreat from an intruder. But you might not, depending on the state, because it's not your castle. You might still have a legal duty to retreat. Another way it can vary is against whom you can apply castle doctrine privileges. In other words, if you have a genuine intruder in your home, well, that definitely triggers the castle doctrine. But what about if that other person is an invited guest? They're there by license. They're not a genuine intruder, or they're a co-dweller. It's also their castle. Some states will say, well, you don't have a legal duty to retreat in your castle from an intruder. But if it's also their castle, we reimpose the legal duty to retreat. So all states have some form of castle doctrine, and it always applies if you're in your castle dealing with a genuine intruder, but it may not apply in more complicated scenarios. And by the way, I just want to say, I want to remind folks, if you get into a confrontation, a physical confrontation, you've just incurred two risks you were not incurring a moment before. A greater than zero risk of dying and a greater than zero risk of going to jail for the rest of your life. There's no way to reduce those risks to zero. If you're in a fight, I don't care how good you are with that gun or BJJ or anything else, it could just not be your day. When we train for the physical act of self-defense, what we're trying to do is get that risk as close to zero as possible. It's never zero. And the same is true of the legal fight. There's no way to reduce the risk of the legal fight to zero. You could be the most innocent client who's ever walked into my office. And if I have to put you in front of a jury, there's maybe a 10% chance you're going to jail because juries are unpredictable. There's no way. You take my classes, you read my books, and I sure hope you do that. Much appreciated. What we're doing is we're reducing the risk of that as close to zero as possible, but it's never zero. So the reason I teach this stuff is not as legal theory. I'm not trying to run an academic program. I want you to understand the legal theory, but for a very concrete reason. I want you not to fight fights you don't have to. I want you, if there's any safe alternative to fighting, I want you to take it, because I don't want you to incur those risks of dying and going to jail for the rest of your life. At the same time, there are events in which you have to fight. And if you have to fight, you need to be able to flip that switch and go 150%. Nothing's more important than winning that physical fight. If you don't win the physical fight, everything else becomes less pressing, right? So you have to win that physical fight. The reason I teach this stuff is so folks know when that boundary has been reached where they can lawfully go 150%. Because if they know what they're doing is as lawful as it can be, then they can act decisively. They don't end up going for the gun, hesitating, wondering if it's the right thing to do. They know the legal conditions have been met, and they can act decisively against that attacker.
Is your car considered your castle if you're in it?
It depends on the state. So when we say castle, what I really mean by that is what I call highly defensible property. That always includes your home, but some states define it more broadly to include your place of work or an occupied motor vehicle. Florida includes all three, is my recollection, as highly defensible property, in which case you would get castle doctrine privileges and all the special provisions that come along with defending highly defensible property. But not all states include that, and some states make it quite complicated. So, for example, in Ohio, the occupied vehicle is a highly defensible property with all these special privileges for using force, but only if the car is owned by an immediate family member. And then another statute defines immediate family member. And it may not be the family members you would normally think of. Like I believe grandparents are not included, for example. So it creates kind of a jump through the hoops framework where there's a lot of detail. And if you get any facet of the detail wrong, you miss that hoop and you don't qualify.
All right, we're going to end up wrapping this now, guys. We've had Andrew as a guest for over an hour, and we so appreciate him coming by, but we could go on forever. So just a couple of plugs for him and for me. And then if you have any follow-up questions, you can follow up with him. Just as someone had asked if this is going to be replayed. Yes, it's going to be up on the Firearms Nation YouTube channel as a replay almost immediately. So if you missed the beginning, you can catch that. And just like to say to all of you watching, if you don't follow me, you don't follow the channel, please hit subscribe to this YouTube channel before you leave today. You'll get more content like this. You'll get other videos, gear reviews, and replays from the Shooter Summit and other podcasts. And there is, like I said, I've had Andrew on the podcast before, the Firearms Nation podcast. Great discussions. When Andrew starts going on this stuff, we get a lot of answers. So I so appreciate it. But so Andrew, so you got a bunch of things going on that we talked about. So you got your book, so the Law of Self-Defense. What else do you have going on?
So what I really like to recommend to people is the free content we offer because, first of all, it's free, so you don't have to pay for it. It's been my experience that when people see our free content, they end up throwing a few bucks our way. The free content is there's really two best ways to access that. One is we do our own weekly show every Wednesday at 2 p.m. Eastern time, and that's free to participate in. And then after every show, we make it freely available through Thursday as well, the following day, a kind of a 24-hour window, basically. Also free to catch the recording. Now, after that 24-hour window, we do lock the content down for our patrons on our Patreon page, which I'll talk about in a moment. But if you'd like to access the show any week, you can just point your browser to lawofselfdefense.com show. There's no cost. You do need to register because it's a webinar and you need to get the webinar access credentials, but there's no charge for that at all. So lawofselfdefense.com/show. It's a 30 to 40 minute show we do every Wednesday. The next thing for free content is our Patreon page. So, of course, Patreon's known for paid content, and we do have higher value content that's limited to our patrons. But our Patreon page is also where we do our regular blogging, and our regular daily blog posts are totally free for everybody for a week for each post after we put it up. After that, it is locked down for our patrons. But you can go to our Patreon page anytime. There'll be tons of free content there for you. And that's just lawofselfdefense.com/Patreon. And again, that's ongoing. The last thing is we're doing something very special right now. Some of you may be aware that I guess he's a rapper. I don't really know who he is, but some guy named Jay-Z and the parents of Trayvon Martin have produced a documentary about Trayvon's death and the George Zimmerman trial that followed. And it's called Rest in Power, the Trayvon Martin Story. And it's a 6-episode kind of mini series. The episodes play every Monday night. Well, I've watched every minute of that trial and all the pre-trial hearing stuff and read every piece of evidence that was in the evidence file. And I wrote about that trial multiple times every day it was occurring. And I've decided to do an in-depth debunking of this propaganda that is the Trayvon Martin story. But we're doing that through an Indiegogo campaign. So we're asking folks to throw in a few bucks to fund our ability to basically stop doing our normal work for 6 weeks and just focus entirely on this documentary. Contributions are as low as $10, and you'll get access to our critique. And then we have higher tiers that you can contribute if you want, where you get more valuable perks like books and DVDs and such. But it's all listed on the relevant Indiegogo page, so you can see what the options are and choose the one that best serves your interest. I'm very pleased to say we have about 250 contributors at this point. So it's proving quite popular, and people are very happy with the content they've received so far, and we've only just begun. To give you an example, for the first 15 minutes of the first episode, that resulted in a 30-page report that I wrote. That's how intensive this debunking is of the show. So if you'd like to know just about everything there is to know about the truth of Trayvon Martin and George Zimmerman as opposed to the lies, you can go take a look at our Indiegogo page. Just point your browser to lawofselfdefense.com/Trayvon. And if you don't know how to spell that, it's Trayvon, lawofselfdefense.com/Trayvon. And someone posted up my hourly rate's $1,000 an hour. I wish, my wife wishes, but very kind of you to think so.
And I just want to answer this question for Jesse, who was wondering if the guy in the Chicago shooting had a CCW. No, he did not. So, like I said, it's pretty hard to get one in Chicago. He was carrying illegally and, of course, brought the interests of the police. So, Andrew, thank you for quite an informative session. Hopefully we did a lot to debunk the differences of stand your ground, what it means, what it really is, and what self-defense is. People can get a lot more of this information, and I keep plugging it on your book. Sometimes I've gone back to reread certain sections so I have a better understanding of what I'm hearing about in the media. And everybody, if you're out there, be sure and, get some training, and if you're going to carry that gun, you should know the laws. So once again, everybody here, thank you all for tuning in to this live session. Follow me on Facebook to find out when the next one is, and, follow Andrew, and take care, Andrew. Take care, everybody.
Thanks for having me on.